Training. Thank you for joining us today. Today, our speaker is Advocate Vershan Mudley. He's a member of the KZN Bar, soon to be a member of the Joburg Bar as well. I have a very good relationship with him. I brief him often on my construction-related matters, so we work very well together. But another area of expertise of his is administrative and procurement law, which forms a significant part of his practice. So that's what he's going to be speaking to us about today, and I hope everybody enjoys. Vershan, are you ready to go? Okay, let's give him a minute.
Just one second. Sorry, my screen has just minimized. Good morning, everyone. Thank you very much for having me. Thank you, Michelle, for the introduction. Michelle, is the volume okay?
Seems to be. I can hear you.
Okay, perfect. This morning, I've been asked to give a general presentation on procurement law. I apologize, it's not a screenshot, but you will see that the procurement law is obviously emanates from section 217 of the Constitution. But I thought, as a brief outlay to put the rest of the presentation in proper context, I should just itemize the various bits of legislation that cover procurement law and forms the basis of procurement law. Now, obviously, the first one is the Constitution. I'll go through each of these in more detail. We have the Public Finance Management Act 1 of 1999, which is commonly known as the PFMA, rather, the Local Government Municipal Finance Management Act 56 of 2003, which is referred to as the MFMA, Preferential Procurement Policy Framework Act 5 of 2000, which is the PPPFA, the regulations promulgated in terms of Section 76 of the PFMA, and the guidelines published in terms of that section, or subsection 4 rather, the Promotion of Access to Justice Act 3 of 2000, as well as the Prevention of Combating of Corrupt Practices Act 12, the Broad-Based Black Economic Empowerment Act 53 of 2003, and the Standards for Infrastructure Procurement and Delivery Management in the Treasury Instruction, which may be commonly known in the construction industry for infrastructure projects, but it's something that's still in the development. And then we have the Construction Industry Development Board Act 38 of 2000, which I'm sure you're all familiar with. Now, just as a general introduction, what do these various bits of legislation regulate in terms of procurement? It regulates all of the state organs of state in the national, provincial, and local sphere of government, and any institution identified in national legislation. Institutions identified, there are some quasi-governmental organizations which are still required to follow the procurement policies. Private companies are not subject to procurement legislation. The types of contracts that are covered, procurement regulations apply whenever an organ of state contracts for goods and services or sells or leases state assets, and that includes the disposal of other forms of goods, often not for a financial benefit to the entity. So, having just briefly gone through the introduction, sorry, I just want to stop sharing. I suppose we can leave it there. Section 217 of the Constitution is the primary provision which created an obligation on all state organs to have a certain minimum set of standards if I can put it that way, when procuring services or acquiring, purchasing, or selling goods. Now, it generally states the 5 core principles of procurement, which is that the procurement process must be fair, equitable, transparent, competitive, and cost-effective for government organizations. The legislation which gives effect to the general obligation on states as envisaged in Section 217 is the other legislation which I've referred to, the first being the Public Finance Management Act, the PFMA. The PFMA regulates financial matters in the national and provincial governmental spheres. It has some application to other public entities, as I've said. The regulations published in terms of the National Treasury regulations, that's in terms of Section 76 of the PFMA, and added to that circulars developed by the National Treasury that form the basis of guidelines and instruction notes, is what regulates the provincial and national spheres of government. We then have the MFMA, and that regulates, amongst other things, how municipalities and local government and other institutions in the local government sphere should manage their financial affairs. It is not specific to procurement, as the name of the act would allude to. It regulates all financial matters, but it does have provisions which place obligations on local government or local government entities to also have a supply chain management policy. The supply chain management policy is what determines the minimum standards of how those entities procure goods and services. Now, from what I've just said, you would see that it's not one central system. It's known as a decentralized procurement system in South Africa. There is a fair amount of discretion. So although the criteria is spelled out, or the minimum criteria that a procurement process must follow is spelled out in these various bits of legislation, there is no one document that regulates every entity. So all organs of state, both national and in the local government or provincial and local government sphere, need to take from the general legislation and regulations and formulate supply chain management policies which are in keeping with the essential requirements set out there, which cater for all the protective measures, if I can put it that way, that's in the national legislation. So on a practical level, what we have is that if one is looking for the criteria or requirements for a particular entity's supply chain management policy, it would usually be contained in their SCM policy document. Obviously, that document cannot be contrary to what's stated in the national legislation. However, it leaves room for those entities to customize the way they put out procurement tenders to the public for bidding. Now, the Constitution allows organs of state to implement preferential procurement policies, primarily to advance disadvantaged or unfair discrimination. And you'll see a general trend for most of this legislation to have been structured so that we can now have inclusive bidding, inclusive evaluation, and fair and transparent dealing, so that all entities who apply for a tender are treated on equal footing and are given equal opportunities, but also are not prejudiced by any shortfall in other sectors experience or priced because they haven't had the opportunity to develop. So the legislation is changing and currently in the process of change, which I'll get to a bit later on. But that is the general tenet of what the regulations were aimed at. Now, just bear with me a moment. There are certain special industries where special rules apply. Some of the rules, one of which I think I've itemized, is the standard for infrastructure, procurement, and delivery management. Those are, although new, they're around for quite a few years. One of the difficulties that we faced with in the original procurement legislation is that it's not industry specific. And there've been numerous anomalies or multiple anomalies over the years where the regulations and the legislation don't cater for specific industries. I'm using it as an example. The construction industry is one that sometimes projects, given the technical nature and so on, can't be compacted into a specific set of criteria. And there is a move to develop or expand the legislation to become more industry specific and cater for example, the infrastructure procurement and delivery management is not only procurement management, but it's guides how infrastructure projects should be formulated, how the specification should be looked at, what participation should be involved from various sectors, including possibly the public, excuse me, and thereafter regulating the actual tender and the management process of the works that ensue pursuant thereto. Now, there are various types of contracts that procurement regulations apply to. I've already said in general, it's goods and services for state organs. Once the, or let me take a step back. So that's the legislation that regulates it. But on a practical level, tenders are put out, usually in the form of a request for a proposal or a request for bid. And before it is put out in an advertisement, the entity that requires the service of goods must formulate a specification for the tender. So what work or what specification should be included in that? And there are various structures within the procurement process in each government organization. It is generally, according to the regulations, the procurement process itself is overseen and monitored by usually the CFO of the organ of state. So the head of finance is the person that's been sort of placed with the obligations and responsibility to ensure the fair process, a fair process is followed. And the first step of that is the formation of what they call a bid specification committee. And the bid specification committee would obviously formulate the specification of the tender. It includes technical requirements, and many of you may already be familiar with this, so I won't spend too much of time dwelling on it, but they often engage experts, expert consultants to formulate the specification of the particular project. And one can imagine that these projects sometimes are new, innovative ideas. I did a matter not too long ago with a challenge to the tender for the e-nature system in KwaZulu-Natal. And that tender document was so technical, I think it went into 10,000 pages of technical jargon. So the specification process is quite important, and it will dictate the requirements that the prospective bidders or tenderers need to fulfill before they can be considered and to qualify in the evaluation process. Now, once bids are submitted, they then go to a bid evaluation committee, which will evaluate the tenders that it receives. There's also a bid adjudication committee, which is often considered the highest internal body that regulates the process. They will often delegate or appoint people or entities that sit on the bid specification committee and the bid evaluation committee, and those committees usually report to the bid adjudication committee in respect of authorizations or alterations to the initial specs of the project. We need to just dwell on the evaluation process. To do that, we need to look at the regulations, the Treasury regulations. The latest regulations, as I've put up in the slide, is the Treasury regulations of 2017. So it's the Preferential Procurement Regulations 2017. Just to give you a bit of background, the original regulations to the Act, that's the Preferential Procurement Policy Framework Act, was promulgated in 2001. In 2011, those regulations were then repealed and replaced. The primary objective was to include certain criteria which catered and speak to the general objective of the legislation, which I alluded to earlier, which was to cure some of what was thought to be the prejudices and previous disadvantages of certain business entities and individuals in the South African context. So the 2011 regulations then went on to put in certain formulas where tenderers were scored according to a price and preference system. The price component formulated an evaluation on your price, which includes capacity and functionality in certain instances, and your preferential component included primarily your BEE or broad-based black empowerment criteria, where companies or entities bidding for tenders were scored according to legislated BEE point system and rating, and they scored points according to however they fared in that evaluation. Obviously, the highest designated point in terms of the BEE legislation would award a person maximum points for preference. Now, there are two separate systems that were formulated in the Act and in those 2011 regulations. They commonly referred to as the 80-20 point preference system and the 90-10 point preference system. Now, the only distinction between the two, or significant distinction, is that obviously on the face of it, it is the 80-20 would be 80 for price and 20 for preference, or I'll call it loosely the BEE component. And the 90-10 is 90 for price and 10. So in the 80-20 system, a larger emphasis or benefit, if I can put it that way, was given to the bidding entity according to their preference points. The general criteria as to which of these methodologies would apply to a particular tender was solely based on the value of the tender. Over the years, that value has changed, initially being, I think it was R1 million. I don't remember the original, it could have been even lower. So anything below a certain threshold would fall within the 80-20, and anything above that threshold would fall within the 90-10. The current threshold is any awards between 30,000 Rand and 50 million Rand are evaluated on the 80-20 system. Anything over 50 million Rand is evaluated on the 90-10 system. I was hoping to get a slide to show you the formula for how the points are worked out. There's, excuse me. Unfortunately, I didn't get an opportunity to, but in the evaluation process, you have certain scoring or certain point system that will either be, it's guided by the regulations and the Act, but it would usually be specified either in the supply chain management policy or primary document that regulates it in that particular organ of state, or in the procurement document itself. There are various facets that fit in which can be included and are usually included in the specific tender document that the bidder is required to respond to. They can be pre-qualification criteria, which many of you are probably familiar with. There's certain categories of project also determined by value, require or only particular companies, for example, with the CIBDB grading of a certain level, to be entitled to participate or to compete for the tender. Originally, that was primarily the only real pre-qualifying criteria. It formed part of a pre-qualifying functionality criteria. Obviously, if you go into the formalistics of the actual tender process, the first step before all of that would be a clinical assessment as to whether the tenderer has submitted all the required information. And very often we see cases where people or entities rather are excluded from further evaluation because they just haven't complied with the general requirement or submitted all the necessary documents, which would include your company profile and a whole lot of other administrative documents together with your full response to the tender. But there have been in the past a secondary inquiry as to a pre-qualifying functionality assessment, where you have to have a minimum capacity. Often it's specified in certain employees having specific experience, or the entity itself having experience in similar types of projects for other organs of state. Often they are also specified, you must have at least done 3 previous projects of this value, and those are things that are not catered for in the regulations or the Act. It's developed during the tender specification, as I've said, And even if it's not contained in the SCM policy, particular tenders may require, because of the technical nature or the unique nature of it, specific qualifying criteria on functionality. So that would be when functionality is part of a pre-qualifying assessment. There are components within the price component where price is the primary factor and it's allocated points, either 80 or 90, as I've said, out of the total weighting of 100. So under that criteria, there could also be requirements put in which actually speak a bit to functionality. For example, capacity, where you get allocated points. But at the end of the day, the usual way in which government departments have done it is that that is a determination on price only. And that's the reason why they generally split up the evaluation process as to a pre-qualifying functionality and subsequent price assessment. Now, with regards to the regulations about the weighting, that in the 2011 regulations, just to get back to where I left off, in the 2011 regulations, that was the primary adjustment or amendment or introduction, if you can put it that way, which changed the context in which all government entities specified or structured their tender documents. The most recent regulations is the 2017 regulations. The ambit of the 2017 regulations, or before I get to the ambit, the reason why these regulations were promulgated emanated from a governmental investigation, maybe investigation is too strong, but inquiry as to whether the 2011 regulations were in fact achieving the purpose of, firstly, preventing previously disadvantaged persons from continuing to be prejudiced in the tender process, because that's, as I said, what the formulas were aimed at alleviating, and whether it was actually inclusive of the greater or benefiting the greater businesses within the South African or within South Africa. And what they found is that although it was a convenient way to assess entities, it still left a certain category of entities in a beneficial position, because the 80-20, the 20% or 20 out of the 100 apportionment and the 10 out of the 100 apportionment was a rather small component, so it was said. They weren't adequately given an opportunity, and there were long reviews that went on. There were reports and so on about socio-economic investigations of various Black-owned entities, and they said, no, there needs to be a more drastic enforcement so that big companies don't always benefit from this system, because often they're the ones that have the lowest price. Because not only the lowest price, often you have a select group of companies who can only have the capacity to do certain types of projects, large construction projects and so on. So the 2017 regulations included certain provisions for the pre-qualifying procedure to be expanded. It allowed entities to put in certain criteria which were tender specific or project specific, where only a certain category of entities or individuals would qualify to participate in the tender. And obviously that had to be within reason, within the constitutional imperatives. So it couldn't be arbitrary. So there is some restriction as to what they can do, and it has to be fair and transparent. So they can't use that to say, well, there's 10 people, we're only letting them participate. It's nothing of that, but it's to introduce into the current structure more discretion as to how to expand this to get more local companies benefiting. One example would be that a provision is that 30% of the project must go to companies which are local, where the project is going on, and what they call, they've designated as EMEs, either exempt micro entities, or they've got various categorizations of entities that they've created. I think there's also a QSE. And they've said those entities must prescribe to at least 51% Black ownership. I'm generalizing because that's obviously done in terms of the BEE Act and those qualifications. But so they've basically insisted that if a company is allocated a huge project, that 30% of that goes to local companies within a certain designation. It's become controversial, although I think the intent may have been good and it may have benefits to many of the smaller entities who provide services and goods to government entities. It's been the subject of some litigation, and the matter was for the provision, promulgation of the regulation itself was recently challenged in our courts. It started in the High Court, where the Minister of Finance was taken to or challenged as to not having the power to promulgate the regulation in that manner and form. If you just bear with me a moment, I want to give you the citation of that case. It is Minister of Finance versus Afri-Business. It's a constitutional court matter. The case number is CCT 279/20, 2022, ZACC 04. It was heard on the 25th of May, 2021, and the judgment was handed down on 16th of February this year. Bear with me for a moment. Okay, so yeah, where was I? On 16 February 2022, the Constitutional Court made a final determination and handed down judgment in this case. It was an application for leave to appeal against a judgment of the Supreme Court of Appeal, and they dealt with the actual appeal. The minister, let me start with the High Court. The High Court actually found in favor of the minister and ultimately found that the minister could, or had the powers rather, to promulgate that regulation in the form that he did. And the challenging party, Afri-Business Forum, challenged that decision to the Supreme Court of Appeal, which overturned the High Court's decision and ultimately found that the minister did not have the power to formulate those specific provisions in Regulation 7, 20, the 2017 regulations, I beg your pardon, which gave general discretions. And they said, even though the rationale was sound, and the information that they received from the various surveys and so on may have warranted the implementation of that type or a similar type of regulation into the procurement process. It simply found that the act did not authorize, the act that authorized the Minister of Finance to make these regulations did not go to the extent of authorizing him to make the regulations in the specific form, even if there was just cause for it. So it was a very legalistic argument, not so much about any unfairness or arbitrariness of the regulation itself. It came down to whether he had the power to go beyond regulations that were already specified in the Act. The Constitutional Court, or the matter was taken, application for leave to appeal to the Constitutional Court was dealt with together with the appeal. It was, if I recall correctly, quite a close decision. There were 9 judges, and the final decision was, there was a majority and a minority judgment, 5-4. So the Constitutional Court agreed with the Supreme Court of Appeal and ultimately found that the minister did not have the powers. Now, that was in February this year. What the Constitutional Court, however, did was, I beg your pardon, the Supreme Court had suspended the operation of that decision for a period of 12 months, so of the declaration of invalidity. So they suspended it for 12 months, which presumably, and I must admit, I haven't seen any other judgments or articles on it, would then start operating from the time that the Constitutional Court confirmed that decision. So the regulations, I beg your pardon, the Constitutional Court also directed the minister in the period of that 12 months to rectify the issue. Well, sorry, I'm using the wrong terminology. It's not the Constitutional Court. By dismissing the minister's appeal, they, in essence, reaffirmed the Supreme Court of Appeal's judgment, where the minister was given that period of 12 months. So at the moment, the 2017 regulations are still in place. We do not know how the minister intends on rectifying, whether he probably would amend those sections which were found to be, or he was found not to have the power or discretion to implement. So in the upcoming months, we will probably see significant change closer or towards the 2011 regulations, and the whole business of the minimum of 30%, although there are other sections which, or general provisions, which, as I said earlier, allow organs of state to customize their tender process. So this doesn't preclude them from within the ambit of the Constitution and the prevailing laws to institute, or rather include, certain restricting provisions, giving certain preference to entities within that scoring system. It's going to be difficult for them to justify, however, that we want a certain category of entities to be given preference in advance to enter and participate in the tender process itself. What they may be able to facilitate, and it's a common thread when I say 30% of the contract must be given to local businesses. It's not something new that was introduced in the 2017 regulations. It's been a part of the procurement process even prior to this, that many of the tender documents specify or have certain provisions that require the successful company implementing the services to use local labor, for example, local entities where the project is being carried out. So these things have been, but prescribing minimums may have to be done away with according to the judgment, but the minister will then have, we'll only know once the minister reformulates. I haven't seen anything to indicate that there's a draft document or anything out by the minister. So that's where we stand with the evaluation of the tenders and or what's currently happening. When we, just the last point that I forgot to mention on the 80-20 and 90-10 system, which is a practical one, and I've seen matters where there's grave confusion and difficulty in ascertaining which system to use, more especially when you have tenders that come close to that threshold of, let's say, 50 million or whatever it currently is. They don't change it too frequently, but it may have changed from that slightly. If you have a bidder that bids 40 million and someone who bids 55, one wonders, well, how can the 90-10 system apply when you anticipated in your specification that the project would be more than 50 million, but you now have bids for less than that? So what a organ of state needs to do, especially if it feels that it could come close to that threshold, either below or above, it's entitled to specify in the document that the price of the lowest scoring tenderer would determine whether the 80-20 or 90-10 system applies. It's fairly recent, and I don't know, to be very honest, of any cases which have reported judgments on the issue, but there seems to be general consensus that's how it should be applied. Okay, so let's move on. We have the evaluation of the tender process, and the BEC will then make a recommendation of the highest scoring candidate. So often that's the lowest priced together with the highest BEE component would usually be the highest scoring tenderer. And there's an obligation on the state to appoint the highest scoring tenderer in the procurement process. There are certain exceptions where they can reject or refuse to appoint the highest scoring tenderer, one of which is where they feel that the price is not realistic or market related. So if the entity is concerned of the viability of the bid and whether the actual service or goods that have the subject matter of that tender may be compromised because the highest scoring tenderer's price is not realistic given market related values or amounts, they can refuse to accept the highest scoring tenderer. There is a process in place where they must first try and negotiate with that tenderer as to whether they can provide a market-related price. And that's a process of engagement between the organ of state and that highest scoring tenderer. What the regulations require is that if that is not achievable, then the organ of state can then go to the second highest scoring tenderer and negotiate on the same basis within a defined process. So it doesn't leave, properly construed rather, it doesn't leave too much room for arbitrary decisions because it specifies the circumstances under which that can be done and how it must be done. And it stipulates what must happen if they can't achieve a price from any of the tenderers. They can then cancel the tender, and that cancellation must be before the award of the tender. There are a few other bases on which they can cancel tenders. That if before the tender award is finalized, there's no longer a need for the goods, the specification has changed, the requirement has significantly changed, and so on, those would justify canceling the tender. One of the other procedural aspects within the tender process is that there are usually minimum time frames that are set for the expiry of a tender process. Now, there's no exact time frame because all tenders may require different, or specific tenders may require unique time frames. There may be some that require months to allow a company to develop new specifications, like the eNatus one I referred you to earlier. That took, I think, a year or two with some delays because it was innovative and new technology that was requested. That's what the proposal was about. Others are generally within a shorter time frame, and they try to do it within a few months. Now, the significance of that is that a tender process must be validly extended if it's not achieved, if the process is not completed within the specified time frame, which is usually in the advert and in the tender document, so the tender specification document. And if it is not, and an extension is not obtained by consent with all the bidders who are still within the evaluation process and haven't been excluded by any pre-qualifying criteria, that the courts have determined that that would now render the process terminated and they would have to start again. That's just on a practical level. But I want to get on to once the award is actually made. Obviously, the successful bidder would be satisfied and want to then enter into a service level agreement, which is the usual course. And the service level agreement would encapsulate what's in the tender document and may often have certain further specifications particular to the project. But we more often than not have the situation where we have other aggrieved bidders who often don't agree with the decision that was made or the procedure that was followed. Now that takes us to the more legal aspect, which is, well, what remedies do they have? How do they go about challenging the non-compliance with the legislation, both in the procedural aspect of the entire tender process or the award, rather. And the basis of that is that almost all procurement awards by organs of state amount to administrative actions. And as you know, a challenge to an administrative process, either for procedural irregularity or that the decision was not rational or lawful, is done in terms of PAJA, which I've referred you to earlier. PAJA regulates any challenge to the tender process, and it provides that an aggrieved party to an administrative act or decision can challenge it in our courts, particularly or only the High Court, which is important, by way of judicial review. The court may then grant an order if it agrees that there was a transgression of the procurement legislation, if the procedure was flawed, if the procedure wasn't transparent, if it wasn't fair, if certain methodology was incorrect, if the ultimate decision was wrong, or if the evaluation of a particular tender was not done properly or correctly. The court can then decide to declare the process and the award unlawful and set it aside. Now, the process followed by the aggrieved party is usually, and in almost all circumstances, dependent firstly, or rather, requires the aggrieved party to follow internal appeal processes. So there's an internal appeal that can be lodged. One would lodge a dispute. The tender document would usually set timeframes. The regulations do often set minimum timeframes, but there is some leeway to set a longer time frame. And the organ of state would put into their tender document and possibly the advert a provision which sets out the internal remedy, so the internal appeal process. It's often not done as a very litigious process where you have representatives. The entity who's aggrieved would submit brief grounds on which they contend that the award was incorrect or the process did not follow the prescripts of the Constitution and the subordinate legislation. That appeal is not specifically regulated in terms of the 2017 or previous regulations or the Act. So it's usually the BAC which would deal with that. They can appoint a independent or another party to assess the appeal. Importantly, there was a distinction all along with provincial and national government. Local authorities, many of them didn't have internal appeal processes, which I found quite strange, well, at least here in Natal. And in that case, it entitles the party to review the decision. They've now come up with and I forget the name, it's fairly new, it's been around for 2 or 3 years, but it's only been really implemented in the last few months, as far as I know, in Natal. But it's a municipal appeal tribunal, where it's a central body that now regulates appeals for various municipalities. Other municipalities may have an appeal board that have been set up. We also had on a provincial and national level, or provincial rather, provinces had tender tribunals, which were designated with the task of hearing all procurement-related appeals from various government organs. As you can imagine, because it's a decentralized system and there's no one department that's responsible for all tenders, to regularize it or have some sort of uniformity, the tribunals were set up where aggrieved parties could appeal to those tribunals. On a practical level, and in terms of the legislation, the aggrieved party is also usually entitled to request reasons for the decision. There's usually a time frame set within which the aggrieved party must request those reasons, and after being provided those reasons, lodge the subsequent internal appeal. So the internal appeal process is dealt with, and there's a discretion given to the chair of the appeal. Let's just call it tribunal, for lack of a better word. But there's a discretion as to how the appeal proceeds. It's usually done by written submission, setting out the grounds that the aggrieved party contends rendered the process unfair, unlawful, irrational, or irregular. And the appeal chair can then request other information. It's usually provided to the successful tenderer or the department. Information can be procured in response to that, and they can make a decision on the papers. So an important practical factor is it's not always argument-based, and that's why I said often non-litigious. The party is not precluded from engaging legal representatives to formulate those grounds and assess the matter, to give advice on the matter. Nothing precludes that, but it's ordinarily done at a prima facie level of what's obtained in the reasons, and that's submitted to the appeal tribunal. The appeal tribunal or chair can request oral evidence, they can request further information, they can request or allow argument at that appeal process. But that's solely within the chair's discretion. Now, what are the powers of the appeal tribunal? They would often, if they can refer the matter back if they agree for re-evaluation. It's often the BAC, the Bid Adjudication Committee, that can sit and have another person as the chair of the appeal, but they would refer the matter back to with a recommendation, to re-evaluate. They will make a determination as to whether there is any credence, basically, to the aggrieved party's contentions and whether it rendered the process unfair. If they confirm the decision and disagree with the aggrieved party, then obviously the recommendation would be to go ahead and award the tender to the highest scoring bidder. In that event, the aggrieved party obviously would then rely on PAJA. That's the next step. The reason I set that out is because a requirement in PAJA is that you must first exhaust all your internal remedies before you can resort to an administrative or review of an administrative decision or act. Okay, so to deal with the review, PAJA has, firstly, it must fall within the ambit of administrative action. With procurement awards, it almost always would fall in that ambit. But the Act defines what government decisions and processes form part of an administrative decision or act. It was the debate of, when I say the Act provides for it or stipulates it, it's not clearly specified as these decisions, but it's a set of requirements. And if the decision falls under that, if it's an organ of state exercising a general power that is applicable, I'm saying it in the loosest possible fashion, has an effect of general application on society, it's usually considered an administrative act. Various cases have defined and set out particular exclusions in particular cases. I think Batu Star was one of the first ones, a very popular judgment. The full citation escapes me. But so a lot of cases went on to define it. And the point we had, and I don't think we have the time to go into each of those cases, is that you can take it that government procurement and those awards fall within the ambit of PAJA for the aggrieved party. Now, how does one go about enforcing their rights in terms of PAJA? It's, as I've said, a review application in the High Court, and the review would be brought on the basis of the non-compliance with the procedure or the incorrectness of the decision, which is done by way of application. Almost all review applications are brought by way of application, but I recently came across a comment, and I must admit I didn't go to the source judgment, but whilst going through particular judgment, there was a short reference made to another judgment where it was held that it can very well be brought by action if the circumstances require and if there's a bona fide dispute of fact. I can't go into that judgment anymore. As I said, I didn't lend my mind to it yet. It came up in the last week or so. But you can take it that it's generally always done by way of application. PAJA requires that application to be done as soon as possible from the time the person has knowledge of the irregularity of the process or the decision, but at least within 180 days from when they acquired that knowledge. So it's been construed by many, and I'm speaking just practically within the legal fraternity, that, well, we have 180 days to enforce a client's review application. And that is not quite correct. The Constitutional Court has stated on several occasions, both in obiter and dealing with more specific points, that the 180 days is a maximum time limit. And if you go beyond that, there needs to be condonation, in a sense, applied for within the ambit of the application, explaining why you went beyond that. And although a person challenging it would not ordinarily be questioned on, well, why didn't you bring it as soon as possible? It has certain implications to organs of state reviewing decisions, which I'll deal with shortly. So once the application is brought in terms of PAJA, it's usually brought in conjunction or according to, or in terms of rather, Rule 53 of the Uniform Rules of Court. That deals specifically with review applications, and it differentiates the matter from other applications which are dealt with in terms or regulated rather by Rule 6. It has different time frames that are stipulated in Uniform Rule 6, Sub Rule 5. And the reason for that is because obviously the person challenging a decision or seeking to review a decision rather, is not vested at the outset with the entire, what they call, record of the tender proceedings. So in order to fully challenge or evaluate and criticize the tender process and identify and expand on the irregularities, one would need the records. The records comprise of various minutes of each of the committees, the bid specification, bid evaluation, the BAC. So there'll be minutes of meetings, there'll be evaluation notes, there will be methodologies and calculations that were used to arrive at the final scoring for each tenderer. So Rule 53 provides or makes special provision for putting in a preliminary founding affidavit, which is usually an expansion of your grounds based on the reasons that were provided, and often information that is put into the representations in the appeal process, the internal appeal process. And it provides that the respondent organ of state must provide the record within specific time frames. So they have a month to do that, and the time frames for the usual opposition and the answering affidavit and so on are pushed out slightly to cater for the provision of the record both to the applicant and to the court through the registrar's office. Whereafter the applicant, aggrieved party, gets an opportunity to supplement their founding affidavit to include anything else, any other allegations that it elicits from the documentation, or attach and deal with that record of proceedings itself in support of its case. Whereafter the application follows a rather ordinary course of answering papers, replying papers, and then get set down on a posed roll to be dealt with on the affidavits. Now, there are other avenues available to an aggrieved party to obtain those records. You will know that in terms of CAASA, the aggrieved party is entitled to make a request to any organ of state for public records. Now, the tender record, being an administrative process, falls within the ambit of those public records. So before you even bring a review application, and it's often wise to do it this way, because once you institute an application, you can't use the justification of, well, now I've got the record and I don't think I have a case. So you still have to, there's cost implications, of course, if you decide to withdraw after being provided the record in terms of Rule 53. So as a precursor to the application, you often request that information from the organ of state within the ambit of the legislation, and they're obliged to provide it. If they don't provide it, then you can also bring a short or rather procedural application, if I can put it that way, to compel them to provide it to you. And then your client can assess in advance of even instituting the review application within that 180 days. Another important factor to consider on a practical level is usually the fact that, well, what happens whilst this review application is ongoing? As you know, it can take, it's dependent on court roles. Being an opposed application, it can take many months, in some matters, a few years to be dealt with. So what happens to the service that was to be provided? What happens to the successful tenderer's rights in the interim? Nothing, once you institute the review, is stopped or prevented from going forward. So it's an important factor. It requires, if the aggrieved party requires the award of the contract to be stopped or interdicted through an injunction or interdict process, or any other implementation to be ongoing until the review is finalized, they have to bring a separate application dealing with the interdict and why, in order to maintain the status quo, it will be just and equitable for the court to order that the tender process or the award is not further. So that may entail not entering into a service level agreement. There have been matters where service level agreements are already entered into and works commenced, and interdicts are granted, preventing ongoing work. It's the wisest thing to do as an aggrieved party, because during the process in which the review takes place, if one of the considerations that the court has is the effectiveness of setting aside a process, even if it's irregular. So the common law that has been developed supports the view that one of the inquiries a court must make is to the practical effect of setting aside a process which it has concluded was irregular, unlawful, not transparent, as part of the consideration of what is a just and equitable remedy. And the Enatus example is a good one that I referred to earlier. That matter where the applicant did not bring an interdict, and I was, fortunately for the department, who challenged this, and it went on for many years, and had awarded the contract to the highest scoring bidder, who started implementing the contract. And it went to the High Court. We argued a few points in limine, one of which we were successful on as the department. The applicant took that to the Supreme Court of Appeal, and they overturned that and said the first point in limine is not good enough to extinguish with the matter. And they've now set the matter, or a few months ago had set the matter down on the opposed roll for the balance of the points in limine and the merits. And they were forced into a position before we even went to argument to settle the matter on the basis that each party pays their own cost, or I think it was a nominal cost of the Supreme Court of Appeal that the respondent had to pay, and they withdrew the application. And that was after lengthy papers. It was after many court appearances, and as I said, it was a very technical matter spanning dozens of files and information. So it was a huge cost, and they had to make a judgment call on the basis that the court may likely, after the time that has elapsed, decide, well, this project is now 90% complete or fully complete. What is the practical? We can't set it aside. And it becomes moot. So often in that situation, a court would issue a declarator that the process was unlawful, but not couple it with a order setting the process aside. That takes me to very briefly just go through the powers or what a court would do. A court, even if it finds, a court is there firstly to adjudicate whether the procurement process was compliant with the overriding all the legislation we've dealt with. If it finds that it wasn't, and it should be set aside, a court would ordinarily not substitute the decision of the organ of state. So that's the base principle. It's the separation of powers. So they would ordinarily refer it back to the organ of state within the process of the procurement process to be reevaluated if the irregularity occurred during the evaluation process. If it's a challenge that's broader and more to the efficacy of the entire tender, which they find, they may set the tender aside and refer it back for the department or the organ of state to make a decision as to whether to re-tender this. However, they do have a discretion where the court finds that it's just and equitable for it to substitute itself, it can do so. It's to be exercised according to our developed common law with extreme discretion and caution, and court should be reluctant to try to make decisions for the organ of state. So in certain circumstances, the court may find, well, it would serve no purpose to refer it back, and we will make a decision on it. So I've covered the interdict. Once the, sorry, if you just bear with me a moment. So we've dealt with how aggrieved parties challenge unlawful or unfair, irregular tender proceedings. For a long while, it was thought that this applied equally to organs of state. Well, let me start. Initially, it was a common view that the aggrieved party must challenge it, and the premise was that if a decision is made, it's lawful and enforceable until a court sets it aside. Right? As the common law developed, the Constitutional Court particularly started to place an obligation on the state to review or set aside its own proceedings if it comes to bear or it comes to its knowledge that something was irregularly done. So the court said, well, you as an organ of state can't sit back and rely on this or enforce this unlawful process, inevitably, you have to take steps to set it aside once it comes to your knowledge. It's not prescribed in any law or rather legislation, but initially it was thought that, well, PAJA will equally apply. And if an organ of state wants to set something aside, they had to proceed in terms of PAJA within the 180 days and so on. But the case law had developed to the extent where PAJA was deeply analyzed, and it was found that it does not apply to organs of state. It regulates the procedure and gives the rights to an aggrieved party who attacks a decision made by state. So it left a dilemma as to, well, how does an organ of state then challenge their own process? And one of the factors that often came about in the cases that developed the common law, which was a whole host of them, was that, well, this is generally only discovered by the organ of state, at least, a long time after the award is made. If you take the example of corrupt activities within the tender process, if someone was impartial or acted unlawfully in awarding the tender to a particular entity, especially if the powers that be were involved, it's only generally or often discovered by other officials at a later stage where there's a change of administration and so on. And the battle was, well, do they have to make an explanation as to why they didn't bring it in terms of PAJA? Do they have to apply for condonation? And that was settled when the Constitutional Court decided, well, it's not an application in terms of PAJA at all. It's actually an application in terms of Section 174 of the Constitution, which requires all administrative acts to be lawful and constitutional. And it states that if an act is unconstitutional, an act by an organ of state is unconstitutional, then it must be declared unlawful and set aside. And the court dealing with that can declare just and equitable remedy. The just and equitable remedy was also and still is to some extent, to a large extent, an anomaly, because of course it's a very broad indication, but what it actually includes and excludes is being determined by the courts on a daily basis. For example, it extends beyond administrative action, and we've had private citizens beyond the usual 3-year prescription period for a claim, suing an organ of state based on the provision in the Constitution, which is thought to be constitutional damages and which some courts have stated doesn't prescribe. So it can be used, if broadened too much, as an alternate where someone hasn't enforced their usual civil claim rights. But if we get back to the administrative part of it, I think it's less tricky because there's no conflict with any other law. And through the common law, what has been developed is that a state organ needs to bring it as soon as practically possible. So although there's no legislation that directly sets out a process for the state to follow, because PAJA doesn't apply, they said the 180 days there should be used as a guideline. Obviously, they don't have to apply for formal condonation if it's beyond that, but if there is an inordinate delay, the state organ must fully elaborate, justify why they delayed. And it's one of a big factor, if I can put it that way, that a court will take into account, where even where a process has been unlawful, a court has or courts have in the past refused to set it aside based on the delay that has transpired and the lack of explanation by the organ of state as to why they want to set it aside. To put it in context, a lot of these matters emanate where a third party contractor is trying to enforce a right for payment or performance of some sort, and the organ of state at that point in time realizes, look, we're defending this, and they discover that there was this irregularity in the process, or that there was corrupt activities in the process and so on. So it's often they are given leeway, and the court won't refuse to hear their matter just purely based on delay if it is well reasoned and justified in their papers. So state organs are obliged in terms of the common law to take steps. So it's not really an option, although many of them do. Don't rectify even when they know there's irregularities. There's an obligation placed on them, and this has been quite interpreted in some detail in cases, that they ought to take steps to correct irregular or unlawful administrative decisions or acts emanating from that department or organ. There's no particular sanction if they don't, but they have often been criticized and prejudiced in the fact that when they do eventually do it, a court doesn't take kindly to reactionary or what we call collateral defenses, especially if they knew. Obviously, there are certain justified circumstances where the organ of state would have only discovered the irregularity when action proceedings were instituted against them, and that would be totally justifiable. But the same principles apply as with the ones for an aggrieved contractor, if I can call them that, in the sense that the court may also find that, well, even though the process was unlawful, it's not just and equitable to set the process aside or reverse the impact of the decision. And it's important to note that even if an administrative decision is incorrect or wrong, it remains an enforceable decision until it is changed or set aside. There's a case of Gijima, and I just can't find the full extent. Oh, before Gijima, there was another case. Sorry, I'm trying to remember. It's Buffalo City. It was a few years ago. One of the important recent decisions where the Constitutional Court was required to decide whether to review and set aside a municipality's decision to award a tender to a respondent. The municipality had applied for judicial review to set it aside on its own decision to award the tender in terms of Parja, on the basis that no competitive procurement process was followed. The court in this matter followed the principle in the case of commonly referred to as Gijima. Just forgive me if I don't get the whole citation right. I think it's the State Information Technology Agency SOC Limited versus Gijima Holdings, PTY 2018. I think it's 2 SA, page 23 or 24. The court held, reiterating what Gijima said in the Buffalo City matter, that it is settled law that the organ of state must take steps to set aside its own decision. And whilst the application for a review of the decision in terms of the legislation is being made, it is valid and enforceable and has legal consequences. There have been qualifications, and it was qualified in that judgment, that there may be circumstances where if performance is required by a party based on an unlawful decision, a party can, as I've said, raise and what we call it is a collateral defense to say, this has not been set aside yet, but I should not be bound by it because it is patently flawed or irregular. So it does happen, but not to the extent where a party can just refuse to abide by a decision that's an administrative one until it's properly set aside. They are usually bound by it. It has legal effects. Part of a just and equitable remedy is also, or a court rather, is also entitled to, well, this is a just and equitable remedy, particularly in section 174. A court is entitled to order that the proceeds or benefit, if I can put it that way, of an unlawful award is paid back. What we're finding in recent months, or not months, rather few years, the state investigation unit, SIU, has been mandated by the president to investigate particular cases of corruption and fraud. And they often discover fraudulent activity where the officials of certain organs of state were involved, and therefore the investigations are prolonged, getting information is prolonged, and they discover it a long time after the event. But section 174 is one of the provisions that entitle them to set aside those unlawful or irregular decisions, and in the process to justify or motivate in the application why a just and equitable remedy would be repayment or some sort of compensation for the benefit that the third party contractor had received. They often, if it was based on corruption, would claim back the monies that were paid pursuant to that unlawful process and tainted contract. And they have been successful on many, many of those cases. So there is a very broad discretion as to the remedies that a court will give and the enforceability. As I've said, the courts have also refused to even set aside, let alone decide what a just and equitable remedy is after that. If you'd bear with me for a moment. I'm sure you're very tired of listening to me, and I think I've covered everything I wanted to.
Hi,
Anyone
Vish.
there? Hi,
Yes,
Michelle. You made me
Vish.
think I
Sorry,
was
you
sort of,
froze for a second there.
no, I think Zoom just closed and reopened, but I was hoping I wasn't talking here and not connected to anybody.
No, it was just that last little bit. If you have a look down at the Q&A section, you'll see there's 6 questions there for you.
Oh, sorry, let me have a oh, oh. Okay, the first question from Michelle Rivarola. Can you clarify the notion that a bidder can be disqualified because the bidder has not submitted a document of little or no consequence or relevance?
If you could just read that out, Versh, I'm not sure if everybody can see the
Okay,
question.
sure.
Where
My
it would come from.
understanding is that the only documentation which is preemptory and which can disqualify a bidder is a documentation in the absence of which the state would not be able to conclude a contract with the bidder. Any other documentation cannot be considered to be peremptory and they warrant disqualification, exclusion of the bidder. Michelle, you're quite correct. The courts have developed that formalistic documents that don't have a bearing on the tender are not just cause to disqualify a person. However, it's not just documents that go to the technical nature or the ability of the contractor. For example, a tax clearance certificate in many circumstances has been the justification of excluding a tender from further consideration. The cases are leaning towards, and I can tell you in all appeal tribunals, the obligation on the organ of state, if it's a formalistic thing, to inquire whether it can't be rectified. It was a more strict approach many, many years ago, but certainly the organ of state would not be justified if, I'm thinking of a recent example of a case I've just been instructed in, where it required referee letters from other organs of state. This was a municipality, so other municipalities that you did similar projects for. And attached to the tender document or part of the tender document was a pro forma letter where you had to actually get the other entity to fill that out and sign it at the bottom. And this particular tenderer had gotten the 5 letters, but they didn't get it on the pro forma. So he had gotten it just on a letterhead, which was signed. And he provided it with his tender document, and it's going to the appeal tribunal, but from my assessment of it, it certainly would not be any basis for which to exclude that tender or disqualify the tenderer. So although there's a discretion and there's no set answer as to A will mean disqualified or leaving out B would mean it's okay, it's the discretion that's important. And if it was crucial to the evaluation of the tender and the assessment of risk, for example, which referee letters, that's what they speak to, or financial security in terms of SARS, they could well justify disqualifying that person. I hope that answers that. Michelle, I don't know if you're going to take follow-ups now. Okay, let's go through them. Bosworth Smith asked for a case number. Sorry, I didn't see these questions as I was presenting. Which case was that?
Tiff, maybe you could help us here. I'm not sure how to navigate the Q&A section, to be honest.
Yes, sure. Let me that would be Merv, and I can allow him to speak if he'd like to ask the question directly.
Yeah, can you hear me?
Yes, we can.
Yeah, it was the case number that it began with a 279, given fairly early on in the presentation.
279.
Yeah, version, does that assist you?
It does. It is 279/20. Constitutional Court Judgment, CC T 279/20 in square brackets 2022 ZACC. It's 04, page 4.
Thank you.
And I see CAASA Kempf also has is asking, I don't know if it's the same case number of AfriForum where judgment was delivered in February 2022.
That's the same one, yes.
Oh, same one. Okay, perfect. All right. So that question has been answered then.
Okay, just give me a minute. That was one of my earlier copies that I had saved in my database of cases. I'm just saying often they update the citation, which may make it easier. If I can find it here. Sorry, just 1 second. There's another citation you can take for that case, those of you that are looking. The one I gave you seems to be the correct one for the Constitutional Court law reports. The South African law reports, Juja law reports, the citation is 2022 in brackets 4, so volume 4, SA, page 362.
Thank you.
Perfect, thanks. Then I do see okay, some comments from Uva. I don't know if there's a question there in the Q&A box.
Let me. The next one is here. Okay, there is one here. The CIDB Act awarding or appointing a contractor in terms of a process that is fair, transparent, etc., does not mention competent. Would, in addition of that word, would the addition of that one word not solve a lot of problems arising from the award to the lowest acceptable tenderer? Well, just to answer it in a nutshell, it probably would, but because the word competent is not mentioned, it doesn't mean it doesn't form part of the procurement process, if I understand the question correctly. All the procurement legislation or the actual evaluation process and the specification, the methodology, does include, when you're specifying what information you need, the ultimate aim is to ascertain competence in relation to the price as well. So that's where I spoke about your functionality component and the discretion if you feel that it's not market related. So for example, a qualifying criteria must be that you've done 5 other bridge constructions for over 100 million rand, to use a hypothetical example. You must have staff or manager with 10 years, minimum of 10 years experience in this. And bear in mind that although the CIDB grading goes on, usually the values, as I understand it, and I must admit it's been a long time since I looked at any of the nitty-gritty. All of you probably know more than me about it. But in the assessment for the grading, part of the requirements implies or tries to ascertain whether the person is competent in the sense to do the work. The way they do that is not directly by subjective evaluation of competency, but through the other criteria, the size of the company, the staff, the number of projects they've worked on, the values of those projects, and so on. So it may be disingenuous actually to open up to organs of state the concept of competency, because it's such a discretionary thing that it may allow for a certain level of untoward conduct or corrupt conduct, where even you can justify not giving it to the lowest or highest scoring bidder on the basis that you say, well, they're not competent I think this person's competent. So one has to be cautious introducing provisions that are too open-ended because they can lend themselves to abuse. I hope that answers the question.
Perfect. Then, Vershan, I see a question from Sipo. Section 147, which is with regards to proceeds must be paid back, is from which legislation or act?
The Constitution.
Okay, perfect. Thank you.
South Africa's Constitution.
All right, perfect. I don't see any more questions. If anyone does have any more questions, I can also allow you
You're
to.
welcome to pose it to me verbally, but if that's it,
Perfect.
thank you very much for
Yeah.
affording me the opportunity. I hope it was beneficial. It was a very overview of quite a long process. You can speak to each one of these components and go into great detail about cases and so on. But I hope the general overview was beneficial. Thanks,
Yeah.
Tiffany.
No, thank you,
John.
Vershan. Thank you very much. Yeah, and thank you everyone for joining us again. Yeah, and we'll have a lot more covered next year in our training sessions.
Thank you, everyone. Enjoy your weekend.
Thanks, Versh. Thanks, Tiff.
All right.
Thanks.
Bye.
Thanks, everybody. Bye.
Bye, everyone.